Okay, cool. I'm going to go ahead and get started here. We're going to talk about H2A wage rates today. I'm going to do this just like I do with all the other ones. If you have any questions, just put them in the Q&A, and I'll get to them. They can be on topic, off topic, whatever you want to talk about is fine. Just go ahead and put it in the Q&A, and I'll answer it if I can. So. But today, the topic of conversation is the H2A wage rates, which, as most know by this point, the H2A wage rates were significantly complicated last year whenever they changed the wage rate methodology for occupations that fall outside of the Big Six. So the Big Six occupations, those still use the historical adverse effective wage rate, which was determined by the Farm Labor Survey. But for everything that falls outside of that, which seems to be more and more occupations based off of how the SWAs are assigning SOC codes, they fall under the statewide average of whatever the SOC code is that's assigned by the DOL. And so historically, H2A employers oftentimes didn't really feel the impact as much whenever they had to change wage rates because it happened outside of most H2A employer seasonality. Most H2A employers don't have people here in January, which is when it happened historically, with the Farm Labor Survey being released. But now the way that the OEWS wage rates are released is generally on July 1st. So we don't have the data for it yet, but now it's right in the middle of everyone's season, and so the wage rates there used to be a transition period where you would have publication and then 15 days later or so you would have to actually update the wages. Now this time it is effective on July 8th. So you have to change everyone's wage rates on July 8th, and we won't know what the actual wage rates are until July 1st. But let's talk about it. Okay. Let me share my screen if this here computer will let me. Again, just for anyone that entered, if you have questions that pop up, just go ahead and put them in the Q&A whenever they come up, and I'm going to get to them at the end. So Q&A is generally the part that I find the most fun. We have an hour set aside for this. It's not going to take an hour. So plenty of time for conversation. That's what we need. Okay, great. For those that don't know me, I'm Kyle Farmer. I'm the owner of Farmer Law PC, and I'm just wanting to teach you some things about H2A wage rates. Okay, so just kind of backing it up here. Let's talk about what is the adverse effective wage rate. The adverse effective wage rate is the wage that H2A employers are required to pay their H2A workers and all corresponding U.S. workers. So if you have an adverse effective wage rate that's $18 an hour and you have U.S. workers performing the same job duties, then they need to also be paid at least $18 an hour. And so that's what the adverse effective wage rate is. That the purpose of the adverse effective wage rate is to make sure that according to the DOL, is to make sure that the wages aren't hurting the U.S. labor rates. And so they last year, with that in mind, what they were trying to do by reassigning a bunch of jobs like truck driving and maintenance jobs and construction jobs, they made them fall into the OEWS wage rate survey. And now there's still 6 occupations that fall under the USDA Farm Labor Survey, which are more just regular farm working activities, agricultural equipment operators, those sorts of things. But a lot of them are now falling into OEWS wage rates. And the way that you would know is by referencing your job order. So on your job order, there is an SOC code that is assigned, and the SOC code is assigned by the state workforce agency. So what the state workforce agencies are doing is they're looking at the job description and they're cross-referencing the DOL handbook to determine what is the highest wage rate and assigning the SOC code based off of that. So a lot of times what happens with farmers is you guys are doing a lot of different jobs. And so what you've done before is you filed your applications, put all of these jobs on one application, and it didn't matter because all H-2A workers were paid the adverse effective wage rate, which is based off of the Farm Labor Survey. But now it matters a lot because your workers might be engaged in minimal construction activities, but because that is on the filing, which it should be if they are doing it, you're now having to pay the higher wage rate regardless of what activities the workers are performing. And so that there's the approach that DOL wants you to do is to separate your filings. So if you have people, let's say that historically you filed a certification where you had some workers doing construction activities, you had some workers doing regular crop production, maybe agricultural equipment operation, you just put it all on one certification. Now what the DOL wants you to do is to separate it. They want you to put all of your construction workers on one certification. They want you to put all your agricultural equipment operators on one certification. They want you to keep it separate. And that presents a lot of problems, which we can kind of get into. But that's basically what they want you to do. And based off the job description, they'll assign an SOC code. If it's not within the big six, then it's in the OEWS wage rate survey. The OEWS wage rate survey is the statewide average of whatever the SOC code is that's assigned. So that the important things are that, and the reason we're having this webinar now is because the OEWS wage rate surveys are about to be updated. On July 1st, they'll release the new data, and the updates will take place on July 8th. So that means that workers' wage rates need to be increased, not decreased if it goes down, but it needs to be increased on July 8th. So again, this comes from the OEWS wage rate survey. And if to copy this link down here, because this link is where you're going to find the data. They'll end up publishing the data on FLAG, which is the government system, and you'll be able to search for it. I can actually show you how to do that real quick too. Let me do that real fast. One thing that we also do for anyone that's interested in it, I oftentimes prefer to filter this data. I bet you didn't know that you're going to get on a webinar and have a lawyer show you how to use Microsoft Excel, but there's an option to download the Excel sheet on the government's FLAG system, which is what I just had a second ago. And you'll see on the left side is your states. Oh, sorry. That's because it's national data. You go to state data. And I can send this out with the filters on it if anyone needs it, but data, filter, and let's say that you are in Iowa and you're engaged in truck driving. So you'd be able to pull up your wage rate like that. And again, this wage rate data is the current wage rate data, but this is going to be updated on July 1st. So this will be a new spreadsheet on July 1st that will have the updated wage rates. But that's basically how I always filter them. So what you would do in terms of a process is download this document, look at your job order that's currently active. At the top of the job order, will show an SOC code, filter for your state, filter for your SOC code, and you'll see what your updated wage is. And the wages need to be updated on July 8th. Now let me go back to our handy dandy PowerPoint. So you'll go to that again, that's the website where you'll get the wage rate data, or if you just ask us for it, we'll send it to you too. Remember that as an employer, you're required to pay at least the adverse effective wage rate. Now that this has become a bigger and bigger deal to DOL, and from a compliance perspective, again, it's got significantly more difficult because historically most farmers were not impacted by a change in AWR in the middle of the season because it wasn't during their season. But now, because of how they released the OEWS wage rate data, which is right in the middle of the year, almost everyone's going to be impacted by it. And so you need to change these on July 8th. If you don't, the consequences can be severe. And I don't know how many of y'all have been through a DOL audit, but the thing that really adds up in a DOL audit is back wage issues. So let's say theoretically that you have a truck driving SOC code assigned to your H-2A filing. And so it's at $25 an hour. And then with the new data, it's at $27 an hour. And these are just hypothetical numbers, but so you've got a $2 per hour difference. And from here through the end of your season, your workers work 1,000 hours. Okay, well, the way that the DOL, and you have, let's say that you've got 10 workers. Well, the way the DOL will look at that is it's $2 per hour was the deficit times 1,000 hours is $2,000 a person times 10 workers is $20,000 in back wages. Now, the real problem becomes with wage rate issues. Depending on where you are, the DOL can be very aggressive about debarment with wage rate issues for employers. So they like to pursue debarments whenever wage rates are the issue, especially when it impacts a large number of people. And the other thing is that usually whenever they calculate what are called civil money penalties, they do it on a per person basis whenever it is a wage rate issue. So let's say that you're then subject to a fine of $2,200 a person. That turns your $20,000 in back wages into another $22,000 of penalties. So it becomes a $42,000 issue. So you've got to be really careful about it. And remember that this isn't only your H-2A workers. This is your H-2A workers and any corresponding U.S. workers. So you have to change everyone's wage rates that are applicable here. Remember that through the certification process, and just from a compliance perspective, you need to advertise the actual wage rate that you are intending on paying people. And so this is another issue that I see come up pretty regularly, which is I'm going to go to this next slide here, but the employer brings up, or employer files certification for $18 an hour for 10 workers. Well, then they bring in these 10 workers and they love these 10 workers. These 10 workers are doing a great job. And so they say, you know what, instead of paying them $18 an hour, I'm going to pay them $20 an hour. Well, DOL doesn't like that either, because then what they say is you failed to properly advertise the wage rate. And if you would have, you might have got U.S. applicants. So it's important that whenever you're advertising your wage rate through your job order and your recruitment activities and you're interviewing U.S. workers, that you're actually telling them the wage rate and you're filing the wage rate that you intend on paying. So that's basically the new AWeber stuff in a nutshell. I knew it wasn't going to take anywhere close to an hour, but I also do want to tee this up a little bit. There's a new farm worker protection final rule. Now, this final rule is going to change a lot. It's especially if you are a farm labor contractor. And so we're going to have another webinar that probably will take a lot more time than this one. And I think, let's see here. The date on that one's June 26th. So when is that? Next week? Oh, no, that's sorry. That is this one. But I think, Marissa, when is do you know when we're doing the one on the farm worker protection final rule?
Yes, that's a typo on that graphic. So it'll be July 17th at the same time, 10 a.m.
Okay, July 17th. Okay. And so we're going to send out some registration links shortly for that one, but that's definitely going to be one that you want to attend because it's complicated. There's a lot to it, and it's going to change a lot, assuming that it doesn't get an injunction, but we'll see. But yeah, so that's it. If you're needing to reach out to us, just feel free to email us anytime. info@farmerlawpc is a good one. And we'll be happy to help you with anything that we can, but let's see here. July 17th. Okay, great. And I went through a lot and went through pretty quick. I've done the adverse effective wage rate stuff a bunch of times, but it's important whenever things are changing right in the middle of the season. But what about questions? Do we have any questions here? So the question is, didn't the AWeber change in January? Does this mean that it'll change more than one time a year? That's a great question. So the AWeber changed in January for the big six occupations, the ones that are, so that's the ones that's conducted by the Farm Labor Survey. But you would only have a change in wage rates once a year if you fall within the big six. Actually, you will once a year regardless. It's just a matter of timing. So wage rates change if you fall into big six in January. That's exactly right. And then if you don't fall in the big six categories, because you're performing construction occupations or truck driving or anything like that, or landscaping activities on a farm, those sorts of things, then it's going to change in July. So, but if they're just regular farm workers, then it changes in January like it has before. That's a great question. The question is, where can we read more information about this? I mean, a good spot to read. Let me put this in the chat here. I can put stuff in the chat, right, Marissa?
Yes, you should be able to.
Okay, cool. So this is the website that I just put in the chat is the one that actually has the wage rate data that's coming out. So that was the one in the slideshow. It also has information on the adverse effective wage rate. What are the big six categories, all that sort of stuff. What's the adverse effective wage rate by state? Oh, one thing that we didn't cover, and this does happen occasionally, is what happened, where do I look if I don't have an SOC code that in my state? So, for example, let's say that concrete workers in South Dakota doesn't have an SOC code assignment. There's no OEWS wage rate survey in that. Well, what they do then is they look to the national average. So on that spreadsheet that I was showing y'all, where there's the two separate tabs, instead of using the state specific tab, you would use the national tab for that one. So, but then you would filter it the same way. Just look at the SOC code, and then the wage rate on the far right side would be the applicable wage rate. In the event of an audit, what would the DOL look at as far as the correct wage rate? The SOC code assigned, the job description, or what the workers are actually doing? It's actually a combination of all. This is a really good question. And I think, we don't have a lot of history on this yet, but we have seen what the state workforce agencies are doing to kind of tee this up for DOL. they're actively engaged in the conversation with workers regularly on what are you actually doing, because what the state workforce agency is doing is they're making sure that the employer put the proper job description, which would then give the proper SOC code assignment. So it is possible that an employer fails to, and this is why the job description is so important. It's possible that an employer fails to properly put on their certification an accurate job description, and an inaccurate job description leads to the wrong SOC code. The wrong SOC code leads to the wrong wage, and the DOL could litigate that point with employers for sure. And in fact, I think that they will. And so they're looking at all of those things. They're looking at, okay, what was the SOC code assigned? Were they paying the proper wage rate? Is the job description that they gave consistent with what the workers are doing? So they're going to look at both of those things, and they'll look back 3 years on it. Although this really only changed last year, so it would only really matter for the second half of last year and this year. Oh, this question is okay. Yeah, this is a good one. It is so the thank you. Sorry, I didn't see those in the chat. There's an asylum program fee that a lot of people have started seeing on their I-129. So this is something that the USCIS started charging, and they started charging it to all sorts of petitions. It has nothing to do with your H-2A filing and any kind of assertion that it's going under the asylum program. That the asylum program fee was rolled out by USCIS earlier this year to accommodate the surge in asylum claims being made. So basically, the USCIS is funded through fees, and they needed to increase fees so that they could get through those applications. And the people that are bearing that cost are people that are filing I-129s. And so that's what that is. It has nothing to do with your filing. It's just a funding mechanism for USCIS, and it's just a cost on employers at this point. So the question is, I submitted the I-129 for H-2A. So do I? So I do or don't pay the asylum fee? You do. And then whenever you're filing an I-129, that's another thing that the USCIS recently complicated, is how the fees are determined, because it also that the actual fees for the filing vary based off of the size of the employer. And so you've got to pay close attention to that too. This is another, yeah. So this question is, what's up with Texas not allowing a 3-month experience requirement on agricultural equipment operators? And I don't know. I mean, I know where it comes from. Where it comes from is from the DOL's Field Occupation Handbook. And in that, they survey employers and they say, hey, employers, what's the normal amount of experience you require for this? And their data has determined that it doesn't normally require experience. I don't think that's true at all. That's not my perspective. That's theirs. And so what they're trying to do is to get more people to apply for the jobs. And so they view the experience requirement as making it harder for U.S. workers to qualify for the job. And so if you're going to have an experience requirement, you have to show that it is normal and consistent with industry practices in the area of intended employment. And so what they're saying is, in Texas, that's not the normal practice. You can overcome that burden, but you do have to supply evidence to do so. It's not good enough to just say, I always require 3 months of experience. You actually have to get evidence to demonstrate that's normal in the area of intended employment. But I find that absurd too. I mean, I had to deal with that earlier this year too. So, alrighty. Well, if y'all come up with any more questions before I close this thing out, happy to answer them. But otherwise, after the call here, Marissa will send out the recording, registration link for the next webinar, and the PowerPoint. So appreciate everyone participating.